This is why I think the UK housing market is on the brink of complete crash and collapse. And in this video, I'm going to share with you a few things that you really ought to be aware of, because I've seen lots of videos giving advice in inverted commas about certain things and about how certain things work, which are, with respect, not quite true. In this video, we're going to talk about a range of different things. What happens if you cannot afford your mortgage? What if you are an unmarried couple? What if you are being a guarantor, or you've been asked to be a guarantor for somebody? What if you've been asked to provide a gifted deposit? And what if you've decided to let out your property because you can no longer afford the mortgage, and all of these kind of things? So please do stay and watch right till the end. So this video is going to come with some warnings, some do's and don'ts, and just general things that you really need to be thinking about if you are trying to help somebody who's buying a house or selling a house and so on. So welcome back. I'm the Black Belt Barrister, helping you to understand law. And in this video, talking about impending doom in the UK housing market. As most of you know, mortgages come in a variety of different packages and structures, but the most prevailing feature of a mortgage, of course, is the interest rate. Now, there are around 9 million mortgaged homes in the United Kingdom, and around 75% of those are on a fixed rate mortgage. But if this concept is new to you, it's very simple. A fixed rate mortgage is where the interest rate is fixed for a period of time, typically for 2 years, sometimes for 3, 4 or 5 years, and very rarely more than that. After which the mortgage will be going on to a variable rate, which goes up or down in accordance with both the base rate and the mortgage provider's own internal policies. This is very different, of course, to what it is like in other countries, for example in the United States, where a fixed rate mortgage is typically for 15 up to 30 years. So if you take a fixed rate mortgage, a fixed mortgage in the United States, you typically don't have to worry about the amount changing over that period of time because it's fixed for a very long period of time. But that is not the case in the United Kingdom. Here we have a relatively short period of a fixed rate mortgage, typically, as I say, between 2 and 5 years, depending on the affordability, depending on the size of the property, the size of the mortgage, how many people are contributing to the mortgage, and of course, what the market fluctuations are at the time of granting the mortgage. So in very turbulent times, mortgage companies have been reluctant to provide any fixed rate mortgages, and where they have been in the very recent turbulent times, those fixed rates have been significantly higher than they have been in the past, cutting lots of people out of such mortgages and having the need to have a guarantor, someone who is promising to pay the mortgage in the event that the mortgage cannot be paid by the main account holder. More about that a little bit later, so please do keep watching. Now, out of the 9 million or so homes that are mortgaged in the UK, with around 75% of those being on a fixed rate mortgage, all of those are going to be moved onto a variable rate mortgage. And with the increase in interest rates generally, that's going to see 75% of those 9 million mortgage accounts moving onto a variable rate, which they may well not be able to afford. So we need to look then at what is going to happen to each of those mortgages. Now, on top of all of the variable rate mortgages that are out there at the moment, it's estimated that between October and December this year, an additional 300,000 odd mortgage accounts are going to be moved from fixed rates to variable rates, which are continuing to go up, with reports saying that by the end of 2024, around 5 million UK homes are going to face increases in their mortgage between £2,000 and over £5,000 a year, which is an increase which adds up to around £26 billion a year across the UK for homeowners that have been moved onto variable rate mortgages. Now, as a law firm, we've come across a number of different requests and problems that people have had that they've come to us to seek advice for. Starting at the beginning with first-time buyers, because there are still first-time buyers trying to buy houses, and the banks have recently been reluctant to offer good fixed rates for first-time buyers, and have been insisting on a guarantor, which is simply someone else that will guarantee the mortgage payments are met in the event that the main account holder cannot make the mortgage payments for that month or however many months. And this is where the problem comes in, because some people that are standing in as a guarantor believe if they do get a fixed rate mortgage that they are only being a guarantor for the period of the fixed rate. But that's not quite so, because when you look into the actual details and the documents that are provided by the bank, they are usually required to guarantee this mortgage for the extent of the mortgage account, meaning it's not limited to the 2 years, but for the lifetime of the mortgage. Now, some of these have been 18, 20, 25 years in length, and the guarantor will be on the hook, so to speak, for the full period of time. And in many cases, they are not to be named as a proprietor on the property, and the banks are insisting that they sign a waiver to say that they've had advice, understanding that they have no claim to the property, and yet they are going to be a guarantor for the full mortgage account for the full duration of time. And moreover, in recovering the mortgage amount from the guarantor, they can look at anything that the guarantor has a financial interest in, including their own home. So if the guarantor has assets and or cash, the mortgage company can look to that guarantor to recoup any mortgage payments, any mortgage arrears, shortfall debt, and so on. And just as a word of warning about this as well with regard to mortgage repossessions and forced sales, which I will come back to in a bit more detail later on, but the guarantor should also be aware that mortgage shortfall arrears are not limited in statute to 6 years like an ordinary debt, but because they are linked to property, they are in fact for 12 years, just like the principal mortgage charge on the property. Meaning the mortgage company could come after both the mortgage account holder and the guarantor jointly and severally, because it's joint and several liability for the full amount under the mortgage, for not just the mortgage and the arrears, but if it's eventually sold, any shortfall. And what this means is if the house, let's say, was purchased for £200,000, but let's say it was a forced repossession and then the bank ultimately sold it for £150,000, there would be a shortfall of £50,000, which would be a mortgage shortfall. So just to recap, along with the existing variable rate mortgages that are currently in place, there's estimated to be several hundred more of these mortgage accounts moved from fixed to variable just in the next few months alone. This is going to see each of those accounts have an increase in several £100s as an average per account, meaning that any one of those with the name on the mortgage may not be able to keep up the payments with that mortgage and may have to think of an alternative. But what if it is just simply not possible to sell the property? You may then think about renting the property out. However, this has its own problems, because I know of landlords that have had dozens of their own properties that have abandoned and sold off the portfolio because it simply doesn't work as a business model for them anymore. Why? Well, if you are new to the would-be landlord enterprise, you may not know that you cannot any longer offset the mortgage amount against the income received from the tenant by way of a tax deduction. In other words, you will pay tax on the entirety of the income from the rental, and you cannot deduct from that, before you account it for tax, the mortgage payment. So you will be paying tax on the full income amount from the property, and you still have to pay the mortgage, which in many cases is simply not going to be viable as a business, because very often you might have it on a high loan to value, particularly if you were a first-time buyer, in which case you may still not be able to manage the mortgage amount and pay the tax on any income from the property as a tenanted property. And let's not forget, you will still need the permission of your mortgage provider in order to let out the property in the first place. That's because tenanted properties will typically have a commercially based mortgage, i.e. a buy-to-let or other commercial mortgage that allows you to let out the property. Otherwise, if it is a standard residential mortgage, you will need the lender's permission in order to let out that property. If you are caught letting out the property without the lender's permission, the lender may come back to you and insist that you redeem the mortgage, pay it off immediately, and for which you might need to very quickly find an alternative source of funds. But in the duration that you might have, you might simply not be able to do that, in which case you'll be left in a very difficult position where the lender might be going for possession of the property in order to sell it, in order to redeem the mortgage, because strictly speaking, you'll be in breach of your mortgage covenant, which is the promise that you make to your mortgage company to comply with their terms and conditions. So in short, for the second little segment, not only do I think the housing market is on the verge of collapse from the first, but in the second, I believe that this is also killing the rental market, because it's simply not a very attractive business for landlords anymore, because you cannot any longer set off the mortgage amount against the income from the property, which in any business sense doesn't really make sense, because One way or another, it is a cost that you have to pay before you make any profit from the property. One argument is that this was done to ensure that any ultimate benefit of a landlord owning the property is somehow accounted for in the taxation on an ongoing basis from the income received from the tenant by making the landlord pay that tax on the income but still paying the mortgage amount. But ultimately, I think that is just killing the rental market. Initially, some landlords will just increase the rents to accommodate for the difference, but ultimately, if that isn't in line with market rents, many landlords that I've known are simply selling off the portfolio because it's no longer a viable business. If they are selling off the portfolio, that is going back into either the first-time buyer market or the general market, which are then going to be on fixed rate mortgages, which are then going to get shunted onto variable rate mortgages, see these increases, and then ultimately may end up being repossessed for a variety of reasons that I've just discussed. But this leads us to yet another problem. What if you are an unmarried couple, you've moved into a property together, but one party has contributed a significantly larger sum to the deposit than the other, but you haven't written an express deed of trust as to who owns what in the property, and you are simply joint tenants, meaning you own the property jointly. Now, ordinarily, it would be best practice to write down to protect the interest of one party if they do intend to recoup that deposit later on, which would be best advice and best practice unless there's an agreement to the contrary, because the starting point would be 50-50. Now, contrary to what some videos have said from accounts that I won't name, that's not the whole of the story. On some of those videos, it says, well, there's no choice, it's split 50-50 regardless of who put in what amount of money. But that's not quite true either. Now, of course, as I said, best practice is to have a written agreement as to who put in what, so that there is an express deed of trust as to who put what amount of money in, and they should get that money out again afterwards. But there are also other types of trust, usually by operation of law. They might be a resulting trust, an implied trust, or a constructive trust. Typically, if it can be shown that there was an intention to preserve one party's interest in the property by way of the amount of money they've put into the property, this can be argued in court. Now, there are two distinctly different types of these disputes. They are broadly referred to as TOLATA, which is the Trust of Land and Appointment of Trustees Act disputes, and they broadly revolve around 2 or 3 different case law decisions which the courts look to for guidance in sorting out these problems. I'm not going to go into a great deal of detail on those in this video because we'll go too far off track, and I'll put the names of the cases in the description below if I remember. They are, very broadly speaking, Jones and Kernott and Stack and Dowden. These are 2 different types of case that the courts look to. Very broadly speaking, those are when there is an express deed of trust and when there isn't. And obviously the parties are trying to resolve these issues. But this intertwines with the issue of having a guarantor, because very often there'll be one guarantor to the property, but they are not named as a proprietor on the property. There can be up to 4 proprietors. But if the 2 proprietors are joint tenants, they own the property jointly, but there is also a guarantor on the scene, and maybe the guarantor's son or daughter has put in the chunk of the deposit, that might then give rise to an unfair situation if the couple separate and the departing party wants an equal share of the property, even though it was the other side that took all of the risk. This is again why I say you should never rush into these situations, and you should always, ideally, have everything in writing. This is not always conducive to a very friendly conversation, and it might bring into question the trust between the parties. No pun intended that time. There is also the question over gifted deposits, because a gifted deposit is exactly that. It is a gift, it is a deposit, and the gifting party usually has to sign something to say that they are gifting the money and they don't want it back. They usually also have to sign to say that they have no interest in the property, as I said before, just like acting as a guarantor. If there is someone living in the property, they will usually have to sign a consent to mortgage, meaning they consent to the property being mortgaged and they declare that they have no interest in the property, which is ultimately so that if it goes to court later, they cannot then argue that they can't sell the property and kick them out, because they signed a declaration to that effect and they knew all along that the property was being mortgaged and they might ultimately lose their home if it were repossessed. Moving on to potential problems with a new house, which lots of people don't think about. Now, whether you are selling the property or buying the property, if there have been previous legal disputes with a neighbour, these ought to be declared, because each of these disputes need to be discussed and understood, and your solicitor or conveyancer will have a duty to inform you of certain things, but not absolutely everything. So for some things, unless you ask the question, the solicitor will not be under a duty to tell you. So my suggestion in that case would be for you to ask as many possible questions that you can think of. Because if you ask a question of your solicitor or conveyancer and they fail to answer the question, that might give you reasonable grounds to make a complaint, either to the legal ombudsman later or indeed for negligence if it turns out that it was a very serious issue and they failed to advise you on it. But in some cases, only if you ask the question. So as the saying goes, if you didn't ask, you don't get. So I would suggest that you ask the question. Interesting point of trivia, barristers cannot do conveyancing as such unless they get a license to do conveyancing, although there are certain things that we can assist with, just not with the actual filing of the conveyancing. Now, this whole story might seem familiar to a lot of you because this has actually happened before many years ago. Between the years of 2005 and 2008, a very similar pattern was emerging because there were lots of very good fixed rate mortgages, which after a few years moved on to variable rate mortgages and people simply couldn't afford it. The problem then, which is likely to happen again, is that many of those that try to remortgage their home instead of lose it because they couldn't afford the variable rate mortgages were not able to do so because they just simply didn't have any equity in the property. And the new mortgage company simply said there is no equity or not enough equity in the property to mitigate the risk of the market fluctuations for the value of the property. Therefore, they will decline to provide a mortgage or remortgage on that property, forcing the homeowner into a very difficult situation of try to let it out and balance all of the costs and the risks associated with letting a property, bearing in mind you would have to pay tax on all of the income and get the lender's permission in order to do so, or trying to sell it. However, if the market prices crash, which is a distinct possibility, then there's going to be negative equity and, simply put, they will not be able to redeem the mortgage. Now, it's highly unlikely that a mortgage lender is going to give you permission to redeem a mortgage for lower than the outstanding amount. That is obviously a decision for the mortgage company, but I suspect it's far more likely that the lender is going to repossess the property first and try to sell it itself, as opposed to letting you off the hook, because if they let you off the hook, then word will get out and then everybody will be trying to redeem it for below the mortgage amount. And quite simply, that is highly unlikely to happen. So just remember, if you are about to buy a house, whether that's with a spouse or with a girlfriend or boyfriend, and you're moving in together, or if you're going to be a guarantor or you're going to give a gifted deposit or any of these kind of things, just bear in mind all of the things that I've said, not as advice, but just as general guidance and things to think about. Because so many people rush into these things and don't get their agreements in writing. Remember, as I've said before, the biggest difficulties that I ever see are situations where nothing was in writing. The parties sort of agreed something but didn't even commit it to an email or text messages, so there was nothing to hang that agreement on. Now, the starting position for an unmarried couple is 50-50. The starting position for a married couple is 50-50. However, it will be far more difficult for an unmarried couple to try to skew that away from 50-50 if there's nothing in writing. Whereas for a married couple, the court has a different set of laws under the Matrimonial Causes Act to settle property in a very different way. In both cases, the court is going to look at who resides in the property, typically looking at children and vulnerable people. But very broadly speaking, it is always better to get these things in writing. So if you are in that position, particularly as an unmarried couple, and your partner has asked you to commit your agreement to writing, please don't blame them for doing so, because I would suggest that you do the same thing. It isn't a case of lack of trust. Rather, it is far easier to sort things out for the both of you in case things go wrong down the line. So just remember, none of this is legal advice, none of this is financial advice, but do also remember that if you don't pay your mortgage, you may lose your house, and not just your house, you may lose any other assets that you have if the mortgage company tries to pursue the debt, and they can pursue it for up to 12 years. Not to mention that it will have an adverse effect on your credit rating for a minimum of 6 years, which is how long it will stay on your credit record for, from the last point in time that it can have such an impact on your credit rating. And that in itself is a subject for another video. So I hope you found some of this useful and enlightening. Please do share it with somebody that you know is in or going to be in this situation. And please do like the video and subscribe. That really helps my channel grow, because I really am on this mission to 1 million subscribers to help 1 million people at the very, very minimum. So with that, I thank you for your time and I thank you for watching.